to 5 and 6 to 8 is 2-year diploma in elementary education. As per NRC NCT order dated so and so, program of NIOS is only for those untrained in service teachers in government aided, private unaided schools appointed on or before 10/8/2017. The duration of this program is 18 months. Manas, the second paragraph is extremely important. Yes. Hence, for fresh appointment of teachers for primary and upper primary level, the notifications dated so and so need to be strictly adhered to. TET is also a mandatory requirement. Now, my lords, may kindly have the findings on the letter that I just showed to my lords. It's at para 40 to 41, my lords. In the impugned judgment and order, the High Court has relied on the judgments of the High Court of Patna in Sanjay Kumar Yadav and the High Court of Tripura and Raju Nama. It is to be noted that in the judgment of the High Court of Patna, though a reference has been made to the communication addressed by NCTE to the Additional Chief Secretary Bihar, it brushed aside the said communication on the ground that it is nowhere mentioned that the said course cannot be treated on par with the 2-year training course. In the absence of a specific order of NCTE granting equivalence to the 18 months course with the 2 years course, in our view, the High Court has totally erred in finding that since the said communication does not mention non-equivalence, it would be deemed to be equivalent. We find that the High Court of Patna is totally erred in not giving effect to the stand of NCTE. As a matter of fact, we fail to understand as to why NCTE did not challenge the said order when its specific stands that the said 18 months course was only for in-service candidates and not applicable to fresh ones was rejected by the High Court. We also, this is the finding on that letter, my lords, we also fail to understand as to why with a communication dated 6/1/2021, NCTE decided to accept the judgment of the High Court of Patna. So, my lord, this is what Javir does. And in review, in my respectful submission, the judgment in the main petition has been completely neutered, my lords. Now, my lords, may kindly have another judgment of this court. And I believe, my lords, in the interest, because they might rely on it. It's a judgment of this court in Kaushik Das, because they will rely on Kaushik Das also.
Yes.
My lords, may see Kaushik Das for a moment. Now, Kaushik Das, my lords, again proceeds on the fundamental misunderstanding of Javir Singh, my lords.
It's already a part of Ms. Trivedi's compilation.
This is coming from the state of West Bengal, my lords, where a writ petition was filed that 18-month DLED candidates should not be allowed to complete. My lords, may kindly have.
वाला मैटर क्या
डॉक्टर मनीष सिंह वाला
डॉक्टर मनीष सिंह भी बहस कर रहे थे हाँ
सुखेन मंडल there is one judgment by the name of Sukhen Mandal of this bench. You need to have a look at that judgment also. Madam will provide. Yes.
I informed the court that those were the cases where they wanted the bridge course to be organized for them, because in the clarification application, it was mentioned that people who were appointed between in pursuance of 2018 notification.
They were those who were appointed after 2018, yes. Before 2023.
Before 23. Yes.
This is not the case here.
Correct.
No, that's right. All right. These are people who have been appointed earlier.
Yeah, prior to 2015.
Yes.
Okay. So kindly have para 4.7. I'll just set out the factual context of what was there in this case. This is page 699 of the report, my lord.
Yes.
On 6th July 2023, a set of candidates desirous of recruitment to the post of assistant teachers in terms of the notification dated so-and-so filed a writ petition before the High Court at Calcutta. It was the specific averment that DLED is a course of 2 years and that any candidate who has obtained the qualification pursuant to the program through NIOS, that is by sitting for the 18 months DLED program, should not be considered for the purposes of recruitment in terms of the recruitment notification dated so-and-so. Now, my lords, may kindly have para 7. It's very important, my lord, because this is something that was placed before the court and this is a factually incorrect statement. It is submitted by Shri Shankar Narayanan that all the appellants which were in service as on 10th of August 2017 and further, they had completed the 18 months DLED program through NIOS before 31st March So the judgment of this court in the case of Javir Singh, which covers only such of the teachers who fail to fulfill the above aforesaid requirement, does not oust them in any way. There is no such second category, my lords, in fact, who failed to complete this test, because the 18-month ODL program was only for in-service teachers. There are no persons who were not in service and took this course.
All have which courses?
All of them were in service. All of them took the 18-month course, and they were the writ petitioners in Javir Singh.
They were the writ petitioners.
So this.
It is only for in service.
Yes, sir.
So, my lord, this statement that was made to the court is not factually correct, because Javir Singh covered precisely the first category that is mentioned in the first part of this paragraph, my lords.
So the argument is that only.
No, my lords, it is submitted that all the appellants were in service, and therefore they're not covered by Javir Singh. That is the argument.
Javir Singh deals with in-service candidates.
Yes, my lords. And they are saying that they were in service before 10th of August 2017. And now, my lords, may see what does the court say. My lords, may have para 26. Lords, I'll just quickly, I will not, my lords, may directly have page para 32 only. At page 710 of the report. It can therefore be seen that even though the learned single judge of the High Court placed reliance on paragraph 56 of the judgment of this court in the case of Javir Singh, it came to the wrong conclusion inasmuch as it put a blanket ban on all teachers holding an 18-month DLED through NIOS. As observed herein before, it is clear that the judgment of this court in the case of Javir Singh unequivocally held that the entire scheme emanating from NCT recognition order so-and-so was for the purpose of providing a window to the in-service teachers inasmuch as unless they would have acquired requisite qualifications prior to 1st of April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, any teacher who was in service as on so-and-so and who acquired the qualification by way of 18 months program through NIOS prior to 1st of April 2019 is a valid diploma holder and at par with any other teacher who has completed the 2-year DLED program. Now, my lords, may kindly have para 36. It in extenso quotes Javir Singh. And at para 38 and 39, my lords, it ultimately falls back on the review order that was passed Vishwanath. Not only that, but this situation once again held that such of the teachers who were in employment as on 10th of August and who had undertaken, I'm sorry.
ये कौन सा भी होगा सर?
My respectful submission, and this is by a bench of the same composition, that makes no difference, my lord.
That doesn't
Yeah,
make
that is not relevant. But my lord, may I say this? This second judgment could not have been passed in view of the previous coordinate bench decision. Either the bench should have referred this to a larger bench.
It seems to be on account of some overlap or misunderstanding, if we may say, not
My lords,
that it has taken a different view. We can't say that.
Lords, with respect,
Basically,
it
it
proceeds
seems
on an
to be a little
incorrect
bit of-
factual premise. And that factual premise is that there were some candidates other than those who were in service and who had taken the ODL course. Other than them, there was some other candidate. That is not the correct position. And therefore, my lords, in my respectful submission,
Correct position.
Javir Singh holds the
What you
field.
are arguing is the correct position is laid out
In Javir
in para number 36, wherein Javir Singh is quoted.
Yes, my lords.
We have clarified in the judgment under review that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10/8/17 and
No, this is Javir Singh,
Clear
only, para
para.
36 only, that 14 Javir Singh.
yes, the para 33.
32, 30.
Para 33. It is clear that the judgment of this court in the case of Javir Singh unequivocally held that the entire scheme emanating from NCT recognition order dated so and so was for the purpose of providing a window to the in-service candidate teachers, in as much as unless they would have acquired the requisite qualifications prior to so and so,
They would
they
not
would not
have-
have continued to remain in service.
Yes, my lords.
So that was the broad idea behind Javir Singh.
Yes, my lords.
And the interpretation of the NCT recognition order was only to that extent that the services of in-service candidates had to be protected by giving them one window.
Yes.
That's it.
And in a 2020 exercise, they were seeking parity on the basis of 18 months.
Now they can't say that they have acquired qualification for a fresh
Yes,
recruitment.
my lords.
That is your
that
argument.
is what Javir Singh holds, my lords.
Thank you.
The Khavra,
Very well.
we have given you ample time, and you will have a
Lord.
chance in rejoinder also.
Very well.
Now, my lords, may kindly have two notifications that were referred by my learned friend on the other side, especially with respect to the state of Uttarakhand, my lords.
Extensions.
Yes, my lords. May kindly have those notifications, my lords. That is the notification dated 7/10/2012. That's at page 140 of my compilation, my lords.
Yes.
My lords, may kindly have page 141, paragraph 2. The relaxation granted under this notification shall be valid for a period up to 31st March 2014, subject to fulfillment of the following conditions, namely, the first one is related to TET. The second one basically asks the state governments and school management to amend their recruitment rules relating to appointment of teachers so as to provide for the minimum qualifications required for appointment of teachers laid down under the said notification as amended from time to time. The said notification, my lord, has been defined. It's the 2010 notification.
10
only.
notification.
The state government shall, in the matter of appointment of teachers, my lord, this is very important from the aspect of DLED candidates, shall give priority to those eligible candidates who possess the minimum qualifications specified in the said notification as amended from time to time, and thereafter consider other candidates eligible with qualifications referred to in subclause A of clause 1 of para 3 thereof. Now, this paragraph 3 is really speaking an exception to paragraph 1, where up till a certain cutoff date, people who did not have the qualifications under paragraph 1 can be recruited. Now, this was relaxed. Now, my lords, may kindly also have clause 7 at page 142, my lords. Clause 6 also, my lord, the relaxation specified in this notification shall be one time, and no further relaxation under subsection 2 of section 23 of the said act shall be granted to the state of Uttarakhand. The state government shall take steps to increase the institutional capacity for preparing persons with specified qualifications so as to ensure that only persons possessing qualifications laid down under the said notification are appointed as teachers for classes 1 to 5 after the 31st March 2014. Well, in my respectful submission, these relaxations essentially strike a balance in the sense that if there are sufficient number of candidates with DLED qualifications,
Qualified candidates
that
are
should
well-
never be compromised.
Yes.
They should be given priority, and it is to meet an exigent circumstance. The one side of the coin, my lords, is that it seems that this is to protect the employment of B.Ed candidates. The other side, the flip side to this, my lords, is that the interest of the students should not be hampered and classes should not come to a standstill
If you have
in the
qualified
absence of
DLED,
teachers.
DLED qualified candidates, you give them the preference, and if thereafter
Yes, my lords.
there is any availability, you may consider
and
those
my lords-
people by giving the
And
extension
yes, my lord,
benefit of
in
relaxation.
state of Uttarakhand, that is precisely what has happened.
Hmm.
So over a period of time, so this extension was also extended up till 31st of March 2016 by another notification that came out later.
Hmm.
Now, after that, my lords, what are also happening, may I just take, my lords, through the rules of Uttarakhand also, what was happening there? Because they were trying to match the scheme of these notifications. And the similar scheme also existed under those rules, where the rule said that DLED candidates will always be given priority. And it is only in the scenario where
Is it
sufficient...
anybody's case that sufficient number of DLED candidates are not available in the
No, my lord, that
concerned
cannot be. I
recruitment?
have a chart, my lord. May I just show that chart?
Hmm.
Now, my lord, this is the chart that I have prepared district-wise, showing the number of posts that are notified for each district, the number of DLED candidates who have applied, and the number of B.Ed candidates with a bridge course.
Hmm.
My lords may see for Almora. Post notified is 2,216. DLED candidates 5,819. B.Ed plus bridge course candidates are 809. A similar position, my lords, also exists with respect to others. So state of Uttarakhand was very well justified, my lords, to now amend its rule and say that we will only recruit DLED candidates. Because with the march of time, and my lords, may I just say this? When the 2012 and 2014 notifications were issued, RTE Act was still a fairly new
In the
legislation.
nascent stages, yes.
And now 16-17 years have lapsed, my lords, since the implementation of that law. And law, my lords, with respect, cannot be trapped in amber, and the notifications that have played themselves out with the efflux of time cannot be relied upon, my lords. And my lords may kindly also see that these notifications that have been relied upon by the other side are really speaking of a temporary nature. But there are regulations that have been framed by the NCT in exercise of powers under section 12A, my lords. May kindly have, and those notifications have not been placed before, my lords. My lords, may kindly see page 146, my lords.
Of your compilation?
Yes, my lords. I'm sorry, my lord, not 146. My lords, page 119. I'm sorry, my lords.
190.
119, my lords. Now these are the regulations that have been framed by the NCT in exercise of its powers under section 12A, read with section 32, which deals with the regulation making power of the council, my lords. My lords, may kindly have page 124, 123, my lords. The short title of the regulations is mentioned over there. These regulations may be called the National Council for Teachers Education, determination of minimum qualification for persons to be recruited as education teachers and physical education teachers in pre-primary, primary, so and so.
This is the English version.
My lords, 123, page number 123.
This is the English version.
Yes, my lords, this is the English version. Now, my lords, may kindly have clause 5, my lords, power to relax. Where the council is satisfied on receipt of reference from the concerned state government that special circumstances exist warranting relaxation of some of the provisions of the regulations, it may grant relaxation of that provision to such extent for such time period and subject to such conditions and limitations as it may consider necessary in a just and equitable manner, provided that no relaxation shall be granted. This is important, my lords, under these regulations with regard to the minimum qualifications for appointment of teachers for level 3. Classes 1 to 8 as specified in the first schedule. Now, my lords, may kindly have the first schedule. My lords, may have serial number 3. Minimum, this is for primary and upper primary class. Minimum qualifications as laid down by NCTE with its notification dated as amended from time to time, issued an exercise of powers under so and so. So even that notification, my lords, has now been given the force of regulations, which are now to be considered as permanent over some notifications that were passed to meet certain exigent circumstances. And my lords, may I just conclude by saying this, that the RTE Act, NCT Act especially, is a law that has been enacted by virtue of entry 25 of list 3. And the state cannot now frame rules which are actually repugnant.
Inconsistent with
yes,
that.
my lords. And my lords, may I just say this one factor that perhaps will weigh with my lords, that B.Ed qualified candidates, my lords, can sit even for 9th, 10th and up till 12th. DLED candidates, my lords, cannot. So that is a factor.
Is in your favor.
It is goes in
same way they can't apply for the lower classes.
That's what is.
That works both sides. Both
because
ways.
if the recognition is given to them, then they will.
Different arenas available to both.
Yes,
yeah, so you mean to say they should not encroach in your arena. That's what your argument is.
Yes, that's it. I'll conclude my suggestion.
How what 1 minute?
But the crux of the argument is that 22,917 was not considered.
That's of his argument or their argument?
Of their argument.
Their argument, yes.
Their arguments. If your lordship kindly see 2018 notification once again, only one sentence, my lord.
Please read.
That's last month. 2018 notification.
Yes.
which was considered the second para 2A. It is in the said notification para 3 for subpara A, the following subpara shall be substituted. Who has acquired the qualification of Bachelor's of Education and from any NCT recognized institution shall be considered for appointment as a teacher in class 1 to 5, provided the person so appointed as a teacher shall mandatorily undergo a 6-month bridge course in elementary recognition recognized by the NCT. The only recognition given by NCT is 22/9/17. So that 22/9/17 should be embedded in this notification, and this notification was quashed in Devesh Sharma. All in review, only those in-service candidates were protected. So, my lord, to say that this was 2017 was not considered in Devesh Sharma, it is little misconceived. That's it.
Yes, and now yours.
I am appearing for an Milord, 18-month course, Milord, and 6-month bridge course, Milord. Central government exercise same power, Milord, and is exercise same power, Milord. So discrimination between one giving effect to one and rejecting other, Milord, it is not equitable discrimination, Milord. Therefore, I am supporting this.
All right. You are only an examining body.
Yes,
You are given
Milord,
that liberty to hold that examination. That's all. Why are you taking side, this side or that side?
It is our
You are
course,
given
Milord.
only
It is our
recognition
course,
as an institution,
Yes.
and further to run that course.
Yes.
That's all.
That's all.
You are,
You have charged your fees and you have
you are an executing
Milord, but
agency.
they-
you have
they
made
both
hay
are
while
the-
the sun shone.
Both are from my institution, Milord, so
You
I
are
have
only an
to support.
executing agency, that's
Yes,
all.
Milord, that is for my
No
institution, that's why
substantive-
I support my degree, Milord.
Correct, correct.
That's all.
Yes.
From what I understand from my learned friend's argument is his argument is that the recognition order was not an exercise under 23(1). Now, I had shown my lord section 14 and 15 of the NCT Act, and I had only pointed those sections out to say that that was recognizing course and institution. Now, would my lords kindly just for a minute have page 172 of my compilation, which is that order dated 23rd August 2012. It
This is your
my-
compilation.
The one which has convenience compilation.
This one,
Yes.
with the index on
With
that.
the index, huh?
Yes. So let me just point out what my argument is. My argument was that B.Ed qualification was a qualification laid down by NCTE in exercise of its power under 23(1). It was limited till 2012, later extended to 2016. So there was no occasion for NCTE to again lay down B.Ed as a valid qualification. It was never my argument that the recognition order was an exercise under 23(1). Now just have that for a minute, my lords. May I have page 172. My lords have gone through this many times. Just two things I want to point out.
Yes.
First is the introductory paragraph that this is an exercise of powers under 23(1). So this is laying down minimum qualification in exercise of powers under 23(1). Now have 3, which is then the next page. The minimum qualification which was acceptable till 2012 was B.Ed qualification in exercise of 23(1). There are also two other factors. My lords may permit me to read 3. Training to be undergone. A person with BA, BSc with at least 50 marks and B.Ed qualification, which is minimum qualification, shall also be eligible for class 1 to 5 up to 1st January, appointed till 1st January 2012, provided he undergoes after appointment. So a person having minimum qualification appointed till 2012, after his appointment, he was to go through a 6-month course. Now, there is one thing to be noted is...
Then when that after 6 months would end?
That's right. So now that was, in fact, that is very important because...
Will it continue indefinitely?
No, it would not, and that my respectful...
The moment after 1st January 2012, the period of 6 months expired. So by reading this, it is apparent that after 1st January 2012, no candidate holding B.Ed qualification was eligible to be appointed. That's right?
That's right.
And that such candidate has a window of 6 months.
That's why...
All right.
No,
Yes.
just kindly just hear me out.
Yes, certainly.
The fact that the provision did not prescribe a time period within which the program was to be held that is conspicuous by its absence, because the program can only be held when the NCT holds the program. So if the NCT is not to hold the program, which they eventually held only in 2017, but that would not affect his appointment because his course is after the appointment. So his appointment with minimum qualification stays. That's one. Now, my lords, may have also, this is also borne out from the extension order. My lords, may kindly have the extension order, which is at page 27A. The fact that he held his minimum qualification is borne out from the extension order. My lords, may have 27A. That timeline within which he is to have the program, because it is something that depends on NCT, not on the individual who's being appointed.
Right. Yeah.
So 27A, my lords, may have.
27A of the NCT Act?
No, this is 27A of the paper book, the compilation.
All right.
That's the extension order,
Extension order.
12th August 14.
This was an exercise for extension of that 2012. So what did they do by way of this exercise? They did not relax the minimum qualification. That was not what this relaxation was. They extended the time period within which people having B.Ed qualification could be
do that
awarded.
course.
Qualification and already in service.
Already in service.
Right. To save their service.
My lords,
That's
this,
all.
my lords, this
Does it give a right of fresh appointment? That is what is to be considered.
That's right. So that's what I'm pointing. What did this do? This permitted the state government, on the state government's proposal, to appoint candidates till 2016 who had B.Ed qualification. So if you were appointed till 2016 on the basis of your B.Ed qualification, that was the minimum qualification. This doesn't pertain to in-service candidates. This pertains to fresh appointments made between 2012 to 2016. So recruitment processes that were happening between 2012 and 2016, the state government wrote to an NCT and said that we don't have enough teachers who have DLED. That's what it reads. That's why the extension happened. So between 2012 to 2016, persons having B.Ed qualification were appointed. And that B.Ed was the minimum qualification is borne out from this extension order. My lords, may just give me the indulgence of reading this, order in entirety. Whereas the central government, in exercise of powers under subsection 2 of section 23 of the RTA Act, hereinafter referred to, granted relaxation to the state government of Uttarakhand for a period up to 31st March 2014 by the notification dated so-and-so, dated 17th October 2012. My learned friend read this notification. And whereas the state of Uttarakhand, vide its letter dated 25th March 2014, submitted a proposal to the central government for extension of relaxation under 23(2) of the RTA Act for a period of 2 years beyond 31st March 2014. So this was not for in-service, this was for fresh recruitments. And whereas the central government has examined and considered the proposal of the state government for extension of relaxation granted, now therefore in exercise of powers conferred under 2 of 23, the central government extends the relaxation to the state government of Uttarakhand in respect of minimum qualifications notified by NCTE, referred to under subsection 1 of 23. This is important because that's my case, that minimum qualification of B.Ed is under 23(1) of the RTE Act insofar as it relates to class 1 to 5 and allows person referred to in subclause A of clause 1 of paragraph 3, which is B.Ed till 2012, later extended to 2014 and by this extended to 2016 of the notification, as amended from time to time, eligible for appointment as teacher, fresh recruitments for class 1 to 5 beyond the 31st March 2014, subject to the fulfillment of the conditions under. I'll skip all of that. I just want to read clause 5.
Yes.
Because clause 5 also supports my argument that B.Ed was a qualification, minimum qualification under 23. The state government and other school management shall ensure that teachers employed or engaged by them who possess the minimum qualification referred to in subclause A of clause 1 of paragraph 3 of the said notification undergo after appointment an NCTE recognized 6-month course. And this is dated 14th August 2016. It was extended till 2016 and the recognition order comes on 22nd September 2017. So till 2016 we had...
Clause 5 again.
Yes.
It speaks of teachers who are already employed or engaged.
No, my lords, there was no need for extension for teachers already appointed. Those who were appointed.
Because that bridge course had to be acquired in a certain period of time within 6 months. So that was not done. That is why these extensions.
No, the extension is for fresh recruitment is my case.
All right, that's your argument.
The state government and other school managements shall ensure that teachers...
You would have to then also explain to us the notification which Mr. Rajada has shown to us regarding this notification of NCT dated 12th November 2014, which says that no relaxation with regards to minimum qualifications.
I will just come to that because that also says minimum qualification. My case is that B.Ed was minimum qualification.
Right.
So therefore that notification will not apply. My lords may bear in mind that DLED 18-month course was for those teachers who were completely untrained. So those may perhaps fit in this. But since B.Ed was a minimum qualification under 23(1), that notification itself will not apply to B.Ed teachers. That is what two things say. One, this notification of 12th August 2014 itself recognizes that B.Ed is a minimum qualification. So that notification may pertain to other untrained teachers who were appointed who finally did their DLED 18 months course, but cannot apply to those teachers who had B.Ed because B.Ed was a minimum qualification under 23(1). Then, my lords may see that second proviso of RT Act. Case, my lord, that proviso also page 14 at page 21 is section 23. The DLED course, for example, was for people who had no qualification at all. They were completely untrained. They came and they just joined schools. So those were people who could be said to be lacking minimum qualification, but not a person who has B.Ed when B.Ed has specifically recognized in 2010 and later in 2014 to be minimum qualification. That sub-clause, which was the proviso which was added by the Amendment Act in 2017, which is the second proviso.
Yes.
This also, my lord, did not pertain to B.Ed teachers. It says provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down shall acquire such minimum qualification within a period of 4 years. That is why they held that DLED 18 months course because the 4 years period was coming to an end in 2019. This did not apply to B.Ed teachers. My lords, my learned friend had also pointed out those paragraphs. May I continue?
Yes.
My learned friend had pointed out those paragraphs in Devesh Sharma where the court held that B.Ed teachers were not suited to give education, provide education to primary school students. For that reason, my lords, I have already pointed out the course structure, that this 6-month course structure by NCTE was to meet that requirement. My learned friend then relied on Naveen Kumar. Now, Naveen Kumar is a case which does not at all apply. My lords, may have Naveen Kumar for a minute, that it was handed over yesterday.
देखिए भाई कल की जजमेंट नहीं रखते हैं अलग.
Where is that he will belong? Exemption. अच्छा, वो कहाँ पर है?
You want the
Naveen Kumar, yes.
Also, I just want to address one small point which my learned friend made on this extension. My learned friend said that this was only, he read those paragraphs where preference was to be given to DLED teachers. That was in fact the case. That is when appointments were being made from 2012 to 2016. preference was given to those persons who were already having DLED qualification. That has no bearing on these recruitments because now we are talking about persons who already stood appointed in 2016. So this extension, when it applied till 2016, it is right to say that preference was to be given to DLED teachers. So this paper that he has today handed over saying now this is the number of DLED teachers we have and these are the number of BEd teachers will not apply today because today we are all teachers who had minimum.
Why won't it be? Because preference in any event is to be given. You see, when we see the comparative status of a DLED course of say 18 months or 2 years as the case may be, how can it be by any stretch of imagination equated with a bridge course of 6 months only?
Now, may I answer?
It can never be.
It cannot be.
Yes.
And that would have.
If you have that number of DLED teachers available, you have to give them first preference. Thereafter, if there is any vacancy, that is what at best your argument can be. Nothing beyond that.
No.
And as the statistics have been shown, there are 5,000 teachers against available candidates against 200 posts. Where's the question of accepting your forms against those posts?
If this argument is to be accepted that BEd qualification is not a qualification laid down under 23(1) as extended.
Qualification for what purpose? That is what is the moot question.
Yes, qualification.
Whether it's a qualification to be considered for continuing the in-service candidates in their positions or saving their position, or whether giving them an independent right of recruitment in a fresh recruitment process. That is where the crunch lies.
That's right. So I must answer that straight away.
Yes.
If my lords were to hold today that BEd qualification was not a qualification, minimum qualification prescribed under 23(1), then that may be correct, that may be the position. But if it is a minimum qualification under 23(1) up until 2016, when all of us have been appointed, now these are persons holding minimum qualification. So there cannot be now today, and this is only a one-time exception, only for persons appointed till 2016. So today, if he holds minimum qualification and I hold minimum qualification and I have experience of 8 years, that distinction can't be made. For that, my lords, may just see how the NCT itself handled it. Just come to 23/8/2010 for 1 minute, my lords. That's at page 172.
Yes.
That distinction can't be made today. It can be made for people who are getting BEd qualification today, not appointed, not in service. Page 172, just see, my lords, clause 4, page 174.
Yes.
This was a provision for those teachers who had BEd qualification, who were appointed before this notification came. They were only having BEd qualification, they were exempt. Have B and C. Teacher appointed before the date of this notification. The following categories of teachers appointed for class 1 to 8 prior to the date of this notification need not acquire minimum qualifications specified in para 1 above. B. A teacher of class 1 to 5 with BEd qualification who has completed a 6-month BTC approved by NCTE. A teacher appointed before so-and-so in accordance with REET. So those teachers now, if they want to apply for fresh recruitment, this will apply squarely. They don't have to go and get a fresh DLED course. And the same is the position with me, because on the date on which I'm appointed, I have minimum qualification recognized by NCT. So today, when there are appointments being made, there cannot be any distinction between me and him because both of us hold minimum qualification. There can be no preference given. Preference was for appointments between 2014 to 2016.
All right.
Anyway.
Thank you.
Well, let's two more things that Naveen Kumar I was showing.
Yes.
And now all these arguments are moot for the reason that in Vishwanath, in the review, this court has categorically said that it will apply to fresh appointments and promotion. So my learned friend may have a point, it perhaps was a reversal.
Completely reverses the original judgment.
But I'll tell my lords why. The bench was the same, so we can perhaps...
Doesn't make much difference.
Yes, but...
Doesn't make a review. If the judgment is reversed, we'll have to weigh which view should be accepted.
Thereafter crystallized by Vishwanath in the transfer petition and Kaushik Das. And the reason perhaps, my lord, that review was disposed of in those terms was because in Javir itself, the court at several places says that this is a one-time exception. So therefore, they did not feel the need to refer it to a larger bench. May I just point out those paragraphs in Javir? Just two paragraphs, my lord, just note down. It's at page 241. That's the reason, perhaps, my lord, in the review, they did not feel the need to refer it to a larger bench. Para 46.
Page 241
To page 241, the judgment starts, and para 46
is on page.
is on page 256. Those were observations in Javir itself, that the court observed that these are one-time exceptions.
Yes.
Para 46, as already discussed herein, INCT recognition order so-and-so was issued so as to give effect to the directives of MHRD dated 8 September 2017, so as to provide a one-time window to the teachers who were already working and who, in terms of the 2017 Amendment Act, were required to acquire the minimum qualifications prior to 1/4/2019. The said order in any case cannot be held to be a direction to the state of Uttarakhand. My lords, make note that. Now, para 52.
Yes.
In view of what has been held by this court herein, we find that the High Court erred in holding that 18 months diploma conducted by so-and-so is equivalent to 2 years, particularly so when there was no material placed on record to hold that such a qualification was recommended by NCTE. On the contrary, the communication dated so-and-so, the directives of MHRD, so also the recognition order showed that the 18 months diploma was provided as a one-time window to in-service teachers to acquire minimum qualifications between 2017 and outer limit. Now, my lords, may I have the review, which is at the next page. Para 53, I'll just read it. I'll read it.
3.
Yes.
That leaves us with the reliance placed by the Learned Counsel for NCT on the judgment of this case in Ramcharan Maurya. There can be no doubt that NCT is an expert body, has a right to prescribe minimum qualification. In the present case itself, by notification dated so-and-so, NCT has done so. As discussed above, recognition order only provides a window for in-service teachers. I'm grateful to my learned friends. This also...
What's the purpose of it?
The purpose of?
Yes.
Yes. So this, at 3 places, the court notes that this is a one-time video. Now, please just see who filed a review. The review was filed by those teachers who were in employment. And that is why the court says that we've already clarified that it is a one-time video, so it doesn't, one-time window, so it doesn't affect you. It is only regarding fresh recruitments which may happen, but not for you are entitled to.
This para 3 in the review order which you are reading is completely in ignorance of the observations made in the original judgment, please. So we would again have to weigh whether this review order does have the value of a ratio descendi, or it is simply an obiter.
Now, my lords, that was clarified by the same judge, and the law therefore does crystallize as of today.
No clarification at all. The original judgment still holds field, please.
Now, my lords, my submission to that was these are later judgments, and so therefore, if there is any scope of doubt, then it is the later judgment.
Which is in ignorance of the earlier judgment.
It is not per incurium, my lords, with great respect, because they know
sub silentio, not per incurium.
My lord, in fact, Javir is extensively considered in the 2 judgments. I'll just come to that also.
Yes.
But my lords clarified that it was one-time video. Since that in several places, in several paragraphs that I pointed out, that exception was made. It was said it is one-time window. Perhaps that is why this was not referred to a larger bench, or the review was disposed of in terms of these directions. Now, my lords, may kindly have the next page, 263, which is Vishwanath. Vishwanath and Kaushik Das are later judgments.
Yes.
Noticing both.
How do they consider para 52 of Javir? Yes. Let us see.
My lords, may have page 260.
Let us first see. Let us see Vishwanath now.
Yes,
first.
260.
No, rather, yes.
267.
Yes, read where Javir's para 52 is considered.
The reference to Javir is at paragraph 10. But first, before I go to para 10, may I read para 1.
Para 10 of Vishwanath. Yes, let us see.
268.
There are 2 orders in Vishwanath.
No, that's one was the review order, the other was the transfer petition.
Yes.
Para 1 of the transfer, I'm reading now the transfer petition, this is 268.
Yes.
By way of this application, the applicants have approached this court for a direction on the respondent to permit the applicants who are holding the 18-month DLET from NIOS under ODL mode to participate in the ongoing counseling process and to be subsequently be appointed to vacant posts for ongoing recruitments.
Yes.
Then, my lords, may have para 10.
Right.
Challenging the aforesaid judgment and order passed by the High Court, a batch of appeals came to be filed before this court. The said appeals were decided in Javir Singh versus State of Uttarakhand, in which one of us was a member. This court upheld the validity of the 2012 rules. In the aforesaid case itself, this is the bench's reading of Javir.
Yes, yes.
This court has clarified that the scheme which was framed by the government of India via the aforesaid recognition order was done in order to provide a one-time opportunity to such of the teachers who were already in employment as on 10th August 2017 to get a qualification of a diploma course under 23T, which had been inserted by the 20th.
Now read para 20,
Yes.
where the finding is recorded, on which you are relying upon.
Para 20, my lord, sir?
Yes.
Of the
This
same
is the
judgment.
finding which supports your argument,
Yes.
right?
Also para 14, may I just read para 14?
Very well.
Para 12 to 14. It had also been held by this court that the period of 18 months had been prescribed in order to meet the deadline for appointment of teachers as specified in 23.2. Note this was a one-time opportunity to ensure that in-service teachers remained in service. This court had held that it would not be equivalent to the 2-year diploma course, which is the requisite qualification. It appears that there is some confusion in some of the states and therefore review petitions were filed. So the court was conscious of the fact that this was causing some confusion. This court had declined to entertain the review petitions on the ground that the judgment was clear enough. And it held that one-time scheme was provided to safeguard the interest of those teachers who were employed as on 10th August 2017. Then they refer to Vishwanath. My lords wanted me to read.
Read para 20.
Para 20.
How do you support this finding?
Miss Vanshija Shukla.
So para 20 starts no doubt.
No, 21 है वो.
That's 21.
मेरे पास है original, print out original.
No
It
doubt.
starts- Yes, no doubt.
Yes,
This is probably the one which you rely upon.
Yes.
Now read this para.
No doubt that this court has upheld the 2000 rules framed by the state government by date the judgment dated so and so. However, at the same time, this court has clarified that such of the teachers who were already in employment as on 10th August 2017 would be entitled to the benefit of one-time scheme provided by the government of India. This court held that such of the teachers who have completed the diploma course would be treated as valid diploma holders for the purpose of applying in other institution or for
Now, read
promotion.
from Javir Singh, where is this observation existing in Javir?
That is why it was clarified in review.
No,
Review
please.
specifically says so, my lords.
No. It refers to this court had held in which judgment it refers to the judgment dated 28 November 23. Now point out from the judgment dated 28 November 23 that this was held in that judgment that they shall be treated as valid diploma orders for the purpose of applying. Read that, please.
Well, that is why there was a confusion and the court later clarified.
Para 20 is very categoric to the effect that it deals with the judgment dated 28 November 23 and it provides that this court held that the teachers who had completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying. Now, please read from the judgment dated 28 November 23,
Now-
wherein this observation exists.
Now,
as
my lords are right.
it is not there.
The only observations in Javir are repeatedly that it is a one-time
One
bid
time for in-service teachers.
for in-service
Not
teachers.
for the purpose of applying. That is where we feel that the court has gone wrong, plain and simple, in reading something in Javir which was never existent.
Now, my
Never exists. Please request you to read that line from Javir where it is said that it will be
Paragraph 21.
used for the purpose of applying afresh. Read that and all right, we will close the things now.
that is referring to the review order.
No, absolutely no. It refers to 28 November 23, please. No,
So after 28
Mr. Kalra, Ms. Dwivedi is arguing.
Let her complete
Let
and
her
then you
complete.
can take your chance for 5.
My lords,
concerns about a lack teachers, below the exist time may be given, whatever.
They are hearing you patiently.
my lords, this actually is a reference to the review order. So my lords are right.
We will not read in between the lines, though.
It says so, my lords. It
Please
says
read.
so. May I just read it
Judgment
again?
dated
No doubt.
November 23, it starts like that.
No doubt that this court had upheld the 2000 rules framed by the state government. Why did the judgment? This is Devesh Sharma. This is reference to Devesh Sharma.
Yes.
Not to this. At the same time, this court has clarified. The earlier 2811 is the Devesh Sharma judgment. Javir Singh judgment.
Yes.
So I must be candid. In Javir Singh, is there a line which says that they are entitled to apply for fresh
It
appointments?
is not there, rather it is to the contrary. That it is only for the in-service teachers, very specifically.
So therefore, I read out the three paragraphs where the court says this is a one-time window, and later in review, the same court clarifies and says this will apply to fresh appointments.
Very well.
Because my lords, may just bear in mind, these are teachers who have been working.
Yes.
So I am
That's why their services are saved.
But that is why, my lords, my argument was first, I'm slightly differently placed than DLED 18-month course candidates because I did have minimum qualification. That's one. Number two, my lords, I pointed out.
Now, if you get back to the review order,
Yes.
para 3,
Yes.
where was this clarification required? In view of para, what has been observed in para 2,
Yes.
there is the necessity of the clarification in para 3.
That is why the review was disposed of clarifying what the court
No,
intended
there
in
was
Javir Singh.
No, sorry. It completely reverses what Javir Singh holds. Can the same bench do that in review?
Well, there was no curative. NCT has accepted this judgment. NCT was also part of Kaushik Das. NCT was also part of Vishwanath. So having accepted, we are not in curative.
NCT may interpret this judgment in any way they like. We will read what is written in the judgment.
Yeah, my lords will most definitely. So that is my. Now, the other point I wanted to make is that Naveen Kumar does not apply. Naveen Kumar was a case of fresh appointments which were made under the rules after the judgment had already come in the case of Devesh Sharma. So Devesh Sharma, my case is that does not apply. Those were fresh teachers, fresh appointments. That would be all, ma'am. I'm sorry.
Yes, Mr. Kalra.
Sorry. The respondents have to quite an extent been successful to digress the issue, my lord. Therefore, I will make an attempt to bring it back to track.
Yes.
But because the doubt is fresh in my lord's mind, I would want to clarify this because I was the one who argued Vishwanath, Javir Singh, etc., my lord. In fact, Devesh Sharma as well. What weighed in the mind at that time while review was being passed, and my lord, this is a very clear distinction that I would want to make. It is not simpliciter an order passed in review. There are 10 miscellaneous applications for clarifications also listed on the same day, which the cause title records. It is not just review. That is a very, very clear distinction. Secondly, my lord, because I'll just recall and try to assist by the questions that were placed to me at that time when I was arguing this, my lord. The reason is this. That when JB...
We will not read something into...
No, my lord, I'm just trying... Very well.
What deliberation took place you and the court is not relevant.
Very well. I'm just trying to say, my lord, the reason for that clarification, as my lord Justice Mehta put, is important. Because of Javir Singh, my lord would recall that this is a time where COVID came in 2019, 20, etc. And most of the schools where we as petitioners were working were shut down. So therefore, as a ground in the review as well as in the MA, my lord, one of the primary grounds we took is that the intent of the legislature as well as NCT, which is still not responded, was never to leave us jobless. That was never the intent.
So you are not jobless.
Well, that is what I'm coming to.
Services are protected.
Maximum schools, let me please clarify that. Maximum schools where we were working across the country were shut down because all these were private schools.
That's a factual dispute. We did not go into that.
No, Malaj, I just want to clarify that what was the need for that clarification which came in Javir Singh? The need for that clarification was...
As it was argued from the respondent side, you can always apply for the higher classes. Who prevents you?
My lord,
do that. Simple as that.
Very well. I will come.
Why
I'll come to
that.
I'll come to
primary schools.
I'll come to that, my lord. My lord, also this one. The first, as I said, that the intention was because Javir Singh, when was given, the impression was that there were two classes of people: one who were in service, one who were not in service. Have come.
Forget about everything else.
Very well.
Your argument is premised on the fact that you have been you have lost all the opportunities, which is incorrect.
No,
because
it's not.
Having the BA degree, you can very well apply for the secondary classes, senior secondary classes.
It's not
No
that.
dispute.
It's not that, my lord. I must correct myself
You
if
can
that is the
apply-
impression.
You must have applied, your candidates must have applied in the
It's
meantime.
not that.
There are many recruitments which must have taken place.
It's-
Having,
Most of them were.
No, it's not that, my lord. I must clarify. I must.
it is not that all windows, all avenues have been closed.
No, my lord. It's
But-
not that. It's
but
not
the
that.
But the legislature in its own wisdom and this court in Devesh Sharma has clearly provided that for primary school, DLED is the holy grail. That's all.
My lord, what has not been shown till now, because please bear with me, my lord. There's something I want to
Yeah,
show.
yeah.
If you-
Please.
All right, we'll sit tight as idols to keep on.
No, my
All
lord,
right.
that is not the intent.
Yes, okay.
What I'm trying to say is this. Devesh Sharma, one of the orders which I have placed now as a final compilation, this is the last one, records that B.Ed plus bridge course is equivalent to DLED. That is recorded. What am I praying today is not that please lower down the minimum qualification. What I am trying to pray before my lords is that B.Ed plus bridge course which I have done is equivalent to DLED. So when it is equivalent to DLED, there is no question of lowering down the minimum qualification, and Devesh Sharma records that.
You argued in your.
No, my lord, one order has not been shown.
arguments.
One order has not been shown. And another question, my lords, put that 6 months bridge course, 18 months diploma in elementary education. How can you equate both of them? For that, please see my last compilation, which has just 5 documents, which I would want to show. It's a fat one because it has everything.
Rejoinder, a new case you are.
My lord, what has happened is this. No, it's
don't
not.
allow that, sir.
No, it's not a new case, my lord. These are just all the documents put together. There are no new documents, but there were some arguments as well as documents like the interveners brought in, which was never on record. It was never been filed also. So this is just a response to that. There is no new argument that I'm trying to. It is just flagged for convenience, my lord.
All right.
We have already served everyone. Kindly directly come, my lord, to page 173 for a minute. And we're very pertinent, and I'm grateful for the question that came that how can both these courts at all be equal? Please come to 173 for a minute.
You have shown this.
No,
This chart has been shown to us.
This I have not shown, my lord.
This chart has been shown. Who showed us, we don't know, but someone referred to this chart.
But
That
this
what are the different topics which are covered under. You, Ms. Vivedi showed it. Yes.
Very well. Then please come to page 540, my lord.
Yes.
Page 540.
Yes.
Yes.
So this is an order in Devesh Sharma dated 13th March 2024, which has not been shown till now, my lord. This really holds in my favor to the extent which I will
This
just.
is an interlocutory order passed during the proceeding.
Indeed.
Thereafter, there is a final judgment.
No, my lord, this is
We will
not.
not be relying upon
This is not in the judgment. This is in the clarification, because what the clarification this my lord would see is in the MA. Kindly see 540 top.
All right.
Miscellaneous application 4303. So
Subsequent to the judgment.
this is in the clarification which was passed saying that it will be only to so and so. Kindly come to 541, my lord. Question number 2. In fact, I'll read the entire paragraph. We have heard so and so, so and so, so and so, and the learned additional advocate general so and so, so and so. Let this application be listed on so and so. On that day, we request the Union of India to apprise.
All said and done. Yes. Equivalence, everything.
Lord.
Fundamental question before us is for what purpose?
Indeed,
Is the
my lord.
purpose to save your service or to give you a right or take a shot at a new
Therefore, I
recruitment
was saying
process?
that the issue has been slightly digressed. It is not as if I have not been given fresh appointment prior to Devesh Sharma. Please bear with me for a minute. Prior to Devesh Sharma, all the petitioners here and likewise people who had done this bridge course through this NIOS were being considered for fresh appointment. All of us. It is only Devesh Sharma when it comes in all the states where recruitment was ongoing.
Based on 2018,
No, my lord, we have.
obviously.
My lord.
What else?
My lord, we have done our bridge course in 17. We have not done our bridge course in 18. The Devesh Sharma, the notification comes in 18.
Yes.
And Devesh Sharma notification, as I pointed out in the beginning, is just B.Ed. So therefore, this question is important. Please see this question with me for a minute. Question number 2.
Yes.
Is there a bridge course operating through which B.Ed candidates who were appointed before the judgment of this court, which was delivered on so and so, would train themselves, which would take their qualification at par with DLED candidates? I will pause there for a minute. What this question is saying, that is there a bridge course which will bring the B.Ed candidates at par with DLED? That is the question. Then please see the answer also here. kindly come to the answer which starts at 545. This is the clarificatory order. These words are very, very important. Therefore, I am laying some stress upon them.
Yes, yes.
545, the clarification order starts. And then, my lord, kindly come to 552. 552. Last paragraph, 552. Moreover, the candidates having B.Ed qualifications whose appointments we are protecting in this judgment, my lord, this is Nath, has it?
Yes.
Will have to undergo a bridge course, and we direct the educational authorities to devise such course. Please mark it.
3 lines about this.
Very well, my lord.
Yes.
We make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment delivered on so and so. Mere selection of such candidates or their participation in the process will not entitle them for a benefit under the present order. Then please read this line, my lord. The impression that was there before that bench or whatever before this honorable court was that the class of petitioners like us do not exist. Therefore, the finding here is, the question was, is there a bridge course to equate both of them? The answer is, there is no course, therefore you devise one.
Answer to our query, which we have been making regularly, is there in the lines just above what you were reading.
My lord, there is a...
Very clear. We make it clear that this benefit is only
Indeed,
for
my lord.
candidates appointed prior to.
Indeed.
All right. So even now there is a step further that those who have been appointed prior to 23, they will also get benefit there. But no fresh shot at the new course.
Lord,
That's it.
I will kindly, I will need at least 10 more minutes, my lord. There is something that I wish to show, my lord. It is not as if...
No, we are not saying that we have thrown out your case.
What is
But
being
that's
told
what
here is,
primacy appears.
what is being argued is not that I want a fresh shot. Please bear with me. What I am trying to say is, my qualification because of the bridge course is...
Page 9.
Lord.
Page 9. Failure of any candidate to participate and complete the course within the time frame to be given by the concerned educational authorities
Indeed.
will invalidate the appointment of such candidate.
Therefore, it is helping me, my lord.
No,
it is.
$12.30.
Very well.
Lordship, if I may mention, my lords, urgent listing request of a fresh matter, my lords.
I don't have that jurisdiction.
My lords, the chief court, my lords,
No.
my lords, they're sitting.
Chief court is hearing all mentioning.